Is carrying someone else's prescription drugs a crime in Texas? Let me tell you, the officer thinks it is, and he's going to arrest you. So if you get stopped, and they see this pill container and they pick it up and they see it's got somebody else's name on it, they're going to charge you with possession of a controlled substance because you're not the one it was prescribed to. So yes, you can get charged with a drug offense for carrying someone else's prescription drugs. Prescription drugs are somewhat different from other drug cases in that they're usually a lower penalty range. So, for instance, possession under 28 grams of Ritalin or some of those other ADHD medications is just a Class A misdemeanor, whereas possession of cocaine or heroin of any amount, even under a gram, would be a felony. So if you're charged with, say, a drug possession offense for Ritalin or one of those other ADHD drugs or Xanax, you may be looking at a misdemeanor punishment of up to a year in jail. So it's not as serious as a felony like cocaine or heroin, but certainly a big enough problem. So if you are charged with possession of, say, a prescription drug, and you did not have a prescription for that drug or have that drug in the prescription container, well, if you just didn't have it in the prescription container, but you had a valid prescription for that drug, then we might be able to get the case dismissed for that reason. But if you did not have a prescription, then the defenses are the same as possession of any other drug crimes, the defenses for any of those crimes. So we may challenge the legality of the detention, as it must be supported by reasonable suspicion. We may challenge the legality of the arrest that has to be supported by probable cause. We may challenge the legality of the search that wasn't pursuant to consent or any other exigent circumstances that would keep the officer from having to get a warrant. If you get charged with a drug offense, say for possessing a hydrocodone or some other painkiller that wasn't prescribed for you, but you have a need for it because of the chronic pain that you're dealing with. Well, that might not be a legal defense, but it certainly is an equitable defense that we might use to help you and to try to get the case dismissed based on just the need for that substance to deal with the pain. I think that's certainly an equitable circumstance that can help the client. So quite often for drug offenses, there might be a program such as a diversion program that might be available. And these programs can sometimes help in ultimately getting the case dismissed. So that might certainly be a better option than jail time, which might result in a permanent conviction on a person's record. So quite often for many drug offenses, diversion programs may be available, which ultimately allow the case to be dismissed. Some of these diversion programs may involve a supervised program where a person pleads guilty to the offense, then goes through a counseling program and submitting to urine tests to prove that they're clean, and then the case is dismissed. There are some risks to those cases in that if the person doesn't successfully complete the program, then the judge goes ahead and enters a conviction on their record. There are other diversion programs where that don't involve the requirement of entering a guilty plea, which involve less risk, and then if the person successfully completes the programs and the clean urine tests that are required, the case is dismissed and ultimately can be expunged from the person's record. If you're facing a prescription drug charge in Texas, ensure you get the best representation. Call the Medlin Law Firm.